Hello, my name is Alex Proctor, and I'm the Chief Trust and Privacy Officer at Captain Compliance. In this video, I want to discuss an important but often overlooked topic in privacy compliance: consumer automated privacy opt-outs. Specifically, I'll be covering Global Privacy Control, or GPC, a technical specification that enables consumers to automatically signal their privacy preferences while browsing the web. Before diving into the details, it's important to understand why this topic matters. First, GPC can support legal and compliance requirements in California and several other US states. Approximately half of the comprehensive privacy laws in the US either already mandate or will soon require websites to support universal opt-out mechanisms like GPC. Businesses that fail to comply risk regulatory penalties under multiple privacy laws. Second, GPC is an incredibly valuable tool for consumers. For those who prioritize privacy or simply dislike the repetitive task of manually selecting privacy preferences across multiple websites, GPC streamlines the browsing experience and reduces unnecessary friction. So, what exactly is Global Privacy Control, and what does it do? GPC is a technical standard in development since 2020 to make it easier for individuals to exercise their privacy rights online. It allows users to configure their browser or a browser extension to send a GPC signal to every website that they visit. This signal, transmitted as an HTTP header or a JavaScript variable, informs participating websites that the visitor wishes to opt out of certain types of data processing, particularly the sale or sharing of personal data. There are multiple ways to enable GPC. Some browsers, like Firefox, DuckDuckGo, and Brave, offer native support, while others, like Chrome and Edge, require an extension. The method of activation depends on the browser, but the end result is the same. Once enabled, GPC automatically communicates a user's opt-out preference to websites without requiring any manual interaction. Once GPC is active, it's easy to verify whether the signal is being sent. For example, the Global Privacy Control website provides a tool to check for an active GPC signal. So here I am demonstrating this with Captain Compliance's GPC extension for Chrome, showing the difference between an active and inactive signal. While GPC provides a simple way for users to express their privacy preferences, websites can interpret and respond to these signals in different ways. However, one of the most significant legal implications of GPC is that it is widely recognized as a mechanism for users to communicate a do not sell or share preference. This interpretation is largely driven by California's CCPA and CPRA, which require businesses to treat GPC signals as the equivalent to manually clicking a do not sell or share my personal information link. When a company receives a valid GPC signal, it should, at a minimum, disable tracking technologies, such as targeting and marketing cookies, since these often facilitate the sale or sharing of personal data. Some organizations go further by extending the opt-out to offline or otherwise non-browser-based data processing, especially if the user provides additional identifying information. But that's a slightly more complex and different topic for another day. It's also important to clarify what GPC is not. GPC is not primarily a cookie preference tool, at least in its current state. In other words, it's not intended to manage granular cookie settings, such as allowing functional cookies while blocking performance and advertising cookies, or anything along those lines. Instead, GPC is better described as a legally recognized opt-out signal that businesses must respect in certain jurisdictions. With that said, because respecting the do not sell or share preference frequently involves adjusting cookies, many consent management platforms integrate GPC into their workflows, automatically adjusting cookie settings to block targeting and marketing cookies when a GPC signal is detected. Now let's take a closer look at the legal landscape. California is the most well-known jurisdiction requiring businesses to honor GPC. California also has extremely specific requirements for businesses when it comes to broader opt-out management. As I've already mentioned, Businesses that are subject to Californian privacy law must provide a link on their websites that says, "Do not sell or share my personal information." They also need to respect automated opt-out preference signals, such as GPC, in a frictionless manner. While the law does not name GPC explicitly, Californian regulators have confirmed that GPC qualifies and must be recognized as a valid opt-out mechanism. Beyond California, several other states have adopted similar requirements. In fact, this requirement is already in effect in Colorado, Connecticut, Montana, Nebraska, New Hampshire, and Texas. Additional states, including Delaware, Maryland, Minnesota, New Jersey, and Oregon, are set to enforce this requirement in the near future. Some of the states in that latter group have already enacted their laws, but they have slight delays on the enforcement of universal opt-out right mechanisms. While most of these laws do not explicitly mention global privacy control, GPC is the most widely recognized mechanism for fulfilling the universal opt-out mechanism requirement. For example, if we look at the Colorado Attorney General's website, GPC is the only universal opt-out mechanism officially recognized by the department. GPC has effectively become the standard modern solution for complying with universal opt-out mechanism requirements, although that could change in the future if other specifications are developed. The laws leave the doors open for this. If you operate a website or manage privacy compliance for your organization, it is essential to ensure that your website and consent management platform properly detect and respect GPC signals. At a minimum, businesses subject to laws like the CCPA and CPRA must process GPC signals as a valid do not sell or share request. There is significant risk to not meeting this standard. For example, the very first CCPA enforcement action in California had to do with this exact subject. In 2022, Sephora, the beauty product retailer, was ultimately fined $1.2 million for violating Californian privacy law. One of the main reasons that they were fined had to do with the fact that they were not processing consumer opt-outs in response to universal opt-out signals, like global privacy control. In addition to meeting the minimum bar as required by the United States privacy laws, you may also want to consider whether or not to honor GPC globally, even where it's not yet a legal requirement. Taking a proactive approach may help build consumer trust, streamline compliance efforts, and reduce regulatory risks as more jurisdictions adopt similar opt-out mechanism requirements. Now, let me share a little bit about how Captain Compliance helps businesses and consumers navigate GPC. On the cookie consent management side, our platform is designed to automatically detect and respond to GPC signals. If you are using Captain Compliance for cookie consent management, our platform helps ensure that the cookie-related aspects of do not sell or share requirements are addressed. Also, we have our own GPC browser extension, which allows anyone to send GPC signals from Chrome. We've got you covered from both angles. If you need more information, please feel free to visit our website. It's www.captaincompliance.com. I'll put the link as well as additional contact information in the video description. Thanks for watching.